And so when we said that this topic of tonight was something that we really wanted to discuss, we said, okay, Carol, put it together, figure it out. So Carol, I turn the meeting over to you.
Thank you, Jackie. And let me get us really into the topic as quickly as I can. As Jackie said, I'm the chair of Courts Matter Illinois and have been working on issues particularly of the federal courts, but now also of the state courts in Illinois. And I've been working on them for over 25 years. And full disclosure, I am not a lawyer. So that gives you some sense of what kind of court junkie I really am. So having said that, I'm going to introduce our two speakers very quickly because they are the experts and they are both lawyers. And then we're going to really jump into tonight's topic, which is to look at what I have been calling the very bad, no good, terrible Supreme Court session that we have just come through. And we're only going to look at 5 cases. There have been many more that fall into that same topic, and a few that fall into the topic of, well, that was okay. So, so let me start by introducing you to Carolyn Shapiro, who is a professor of law and the Associate Dean for Academic Administration and Strategic Initiatives at Chicago-Kent College of Law, where she's also the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States and the faculty director of the Constitutional Democracy Project. So she has some credentials around the Supreme Court. Most of her scholarship is focused on the Supreme Court and its relationship to other courts and institutions. So I think she brings a lot of expertise, certainly more than me, to this topic. And I'm looking forward to hear what she has to say on these 5 cases that we're going to discuss. Our second speaker, Colleen Connell, is the executive director of the ACLU of Illinois. She is the first woman executive director of the ACLU of Illinois. And when she assumed that position, she expanded the organization's legislative and communications programs, as well as its programs in national security and the informational privacy docket, and all kinds of other programs. Under her direction, the ACLU in Illinois has adopted a strategy of integrated advocacy using almost every tool at its disposal: public communications, litigation, community engagement, and advocacy, using them strategically and in concert to defend and expand fundamental liberties and rights in the most effective ways possible. What's important to also know about Colleen is that she has argued before the Supreme Court of the United States on important matters, including the rights of women to control their own reproductive health. So, and we will get to that topic, but that's not where we're going to start. I want to start by asking both of these women just how they're feeling about this session of the Supreme Court, sort of in general, what they think about this session and how it compares in their mind with other sessions of the Supreme Court. Is this session different? Did these justices relate to each other and these topics that they dealt with in similar ways to past sessions, or was something else going on this session? And I just got the feeling myself as a court watcher that this wasn't the same. So I'm going to leave it up to both Colleen and Carolyn, to whichever one of you wants to jump in first. But what you think of this session?
I'm going to defer to Carol, and I'm dying to hear her view too.
We're not getting any sound from Carolyn.
You hear
I'm
me
not sure. There you go.
Great. Sorry about that. Well, I was going to say that I was going to suggest that Colleen go first, but I'll try. Well, how am I feeling? Not great. As the short answer to that question, not great in many ways, some having to do with specific decisions, including the ones we're going to be talking about, but not great in terms of what I fear may be coming. And I'll say the thing that worries me the most and has been worrying me the most for a while is the law of democracy. I think that this court has shown a remarkable hostility to voting rights, to election, to free and fair elections. They have consistently and continuously ruled against voting rights plaintiffs, against and in favor of states that are trying to do things that make it harder for people to vote, or make it more likely that there will, or in favor of gerrymandering, partisan gerrymandering, et cetera. And there are two big cases that are on the docket already for the fall that I think are of enormous concern. One is a case called Merrill versus Milligan, which is a voting rights case out of Alabama, in which the plaintiffs persuaded 3 judges and federal judges in Alabama that the Alabama congressional redistricting violated the Voting Rights Act. And the plaintiffs just filed their brief in the Supreme Court today. They're the respondents in the Supreme Court. And I just finished reading it, and it's just remarkable the weight of evidence in that brief, and how completely, I don't want to say dishonestly, the petitioners, the defendants, don't even really address in their brief the actual evidence that was before, and the actual holdings of the Alabama federal judges. So I have a lot of concern about that. There are a number of justices on the Supreme Court who I think would be happy to simply find aspects of the Voting Rights Act unconstitutional, some aspects that barely are in existence given all the other things they've done to the Voting Rights Act. So I have a lot of concerns about that. The other case is a case called Moore versus Harper, which comes out of North Carolina and involves something called the independent state legislature theory. The short version of this is that in North Carolina, which, as you probably know, is a swing state with a heavily gerrymandered Republican legislature, Republican controlled legislature, they made congressional districts that have, for their 13 districts, 10 Republican seats and 3 Democratic seats. And that's in a state that's approximately 50-50 in terms of voters. This North Carolina Supreme Court struck that down as violating the North Carolina Constitution. And the Republican legislators are saying, well, that actually is outside of the power of the North Carolina Supreme Court, because under this theory, which is really, I don't know what better word to use it than extreme. The legislature cannot be constrained by the courts or the state constitution, because the Constitution, the federal Constitution, says that things like time, place, and manner of federal elections are decided by the state legislature. So the theory is that because the Constitution uses this word legislature, no other part of state government can place any limits on what the state legislature does, which means highly gerrymandered legislatures, which the Supreme Court itself has blessed, can create highly gerrymandered redistricting for Congress and pass other laws that will have negative effects on federal elections. There's a lot more I can say about that. I have an entire law review, 60-page law review article coming out later this year or early next year. So I will try not to get too deep in the weeds, but I will end by saying that part of what I personally find most enraging about this threat to democracy and this consistent rulings against democracy, allowing partisan gerrymandering, ruling against voting rights plaintiffs, et cetera, is that way in which democracy then is invoked in opinions like Dobbs, and in opinions like West Virginia versus EPA, and in some of the other cases that that we may talk about, although it's less the other three cases we're focusing on don't use that rhetoric as much, but in both Dobbs and in EPA, the majority talks a lot about the importance of political accountability, of a democratic process, of having the people have a say in the policies. And so that's the rhetoric that gets used in these very important substantive cases, while at the same time, we have these real threats to having real serious threats. And some of them are outside of the Supreme Court, but we are facing real serious threats to our democracy. So that's a cheerful way to start. Now I'll turn it over to Colleen.
Thanks, Carolyn. I completely agree with Carolyn. And I would add to that, I think rather a completely honest view of it. I think that the court has, over the last term, become increasingly ideological and power-driven, and that it deliberately misunderstands not only its role under Article 3 of the Constitution, but deliberately mistakes, the words and the history underlying the individual rights provisions of the Constitution in a way that has yielded really, quite frankly, I think, dishonest results that make a mockery out of the framers' intent with respect to many of the provisions of the Bill of Rights. And the democracy issues that Carolyn just succinctly summarized are going to make it more difficult for the truly democratic forces in this country to right this ship and to really restore protections for fundamental rights, as I believe the framers initially intended. And certainly the 13th Amendment, 14th Amendment, 15th Amendment, and 19th Amendment to the Constitution make even clearer, because I think the jurisprudence over the last 100 years, as the court, up until the backsliding that began under the Rehnquist court, but really amplified under the Roberts court, was really a recognition that certain minority rights, certain individual rights, privacy rights, expression of dissenting viewpoints, religious beliefs that might be minority beliefs. The Constitution was really designed to protect, or the Bill of Rights was really designed to protect those. And the court has really abdicated its role in protecting those rights from, I'm going to say, a faux majoritarian excess, because these aren't real majorities. These are gerrymandered majorities. And so I think for me, the two questions that I'm confronting as both a lawyer and as a civil rights and civil liberties advocate after this court term is both how we have to play the long game. And I think it's going to be a really hard long game to play, because the court has, eviscerated so much of its legitimacy, and with its legitimacy, I think, respect for the rule of law. And as a lawyer, I have to say that without respect for the rule of law, any society ultimately is doomed. And so I think we have to play this narrow and really hard role of criticizing the court's opinion, criticizing in so many ways the illegitimacy of, the process, and yet trying not to completely undermine respect for a rule of law, which is so essential to, I think, a society that really does protect the rights of all, but including, importantly, individual and minority rights.
Okay, well, that was a really up way to get us started. This may not be a very cheerful conversation. So let's really go to some of the cases that we said we discussed. And I thought we'd start with the two. There were actually 4 religion and state cases before the court this year, but we're only going to discuss 2 of them. The 2 that I think were the really big cases. The first that was argued early in the session was the case out of the state of Maine on funding religious schools. Maine does not have enough high schools and because it's such a rural state, it does make what in essence are voucher monies available. But Maine has been very careful about saying we won't fund religious education. And it was sued because some parents wanted their money to go to very religious schools. So that was the case of Carson v. Macon. And then the second case that was decided was the one that is referred to as the praying football coach case. And this was a case where a football coach, the case is Kennedy v. Bremerton School District. This was a case where a football coach at the end of a football game would go to the middle of the football field and pray. Initially, he would kneel on the 50-yard line and pray by himself, but invite others to come pray with him, including his football team. And it became a scene where his football players and other people, it was almost a mob scene. And I think Carolyn may have some pictures to show us of what it actually looked like. But what I'd like is to discuss these 2 decisions and maybe an explanation of these cases, because they are both going to have great impact on education and the separation of religion and state from going forward from here. The ripple effect is already being felt. So you can make a decision about who wants to jump in first.
I'm happy to jump in quickly on this one. I found that the Maine case was not really a surprise given where the court has gone over the past 4 or 5 years with respect to saying that if a state makes a benefit available, or public benefit, as the dissent quite accurately framed it, to, for example, elementary schools, like playground equipment, then it cannot deny, in the words of the majority, that benefit to a school or an entity just because of the fact that it is religiously affiliated. I do think that, as Justice Sotomayor said in dissent, we are now at the stage where that I never thought we'd come. I feared that the worst that would happen, she said, that was that the term separation of church and state would become a slogan rather than a constitutional protection. But she said it's worse than that. It now appears that where the majority is going is that the separation of church and state has become the constitutional violation. And I think in many ways she is spot on. But I think for me, the more troubling case is the case involving the praying football coach, because of the fact that I think that the court majority was both deliberately disregarding the facts that had been presented and that did show, as Carolyn's pictures underscore, that this was not really just the coach praying, that he gathered basically players and opposing players around him to play. So it really became an official action. But I think what the majority also ignored, and that the dissent points out, is the coercive nature of that, particularly with young people. And I will say, at a moment of personal privilege, I went to high school in a town that was probably 99%, if not 100% Catholic, Roman Catholic and Ukrainian Catholic. And even though I was raised a Catholic, I was not prepared for the parish priest to come in and teach sex ed and dating relationships in the public school. And the fact that he gave a very Catholic view of, no premarital sex, and it's a wife's duty and obligation to submit to her husband, was obviously a violation of the First Amendment that was apparent to me as a 14-year-old. The only silver lining I can say of that experience, and perhaps of the court's opinion in Bremerton School District, is that that experience launched me on my career as a civil liberties advocate. So perhaps we can hope that the silver lining, or one silver lining, of this court's term is going to be to launch a whole new generation of civil liberties advocates, because here my experience as a parent intersects with my constitutional law experience, which is that children at a very, very young age, and I'm sure many of you have had this experience, very quickly pick up on it's not fair. And I'm holding on to that as, perhaps, a new generation of civil liberties advocates. But I'm going to hope, and we can talk about this more when we get to the Dobbs decision, that we don't have to wait that long for the payoff, and that we're going to begin to see the payoff with, huge voter turnout and people saying, there's more of us than there are of them, and we're not going to put up with this anymore.
So I, as not surprisingly, agree with everything Colleen said. And I have my own version of her childhood story. I grew up in Champaign, Illinois, in grade school. My parents are on the call, so they know these stories. I was always the only Jewish kid in my class through 6th grade. And we used to have an annual Christmas program where we would sing fairly religious songs. Sometimes they'd throw in a Hanukkah song. Sometimes they just throw in a song in Hebrew. Once it was a labor Zionist song because it was in Hebrew, and I got to sing the solo. But we often sang quite religious Christmas songs, not just jingle bells. And one year, our music teacher played this really beautiful recording of a really beautiful and very unusual and very religious song. It was beautiful. It was I used to sort of stand up there and kind of shuffle my feet and mouth the words to Silent Night and A Holy Night. This song was so unusual, right? It would have been different. And the kids all wanted to sing it because it was so pretty, which it was. And she said, no, we can't do that. Carolyn's in this class. And the kids all came to me and said, say we can do it, say we can do it. So guess what I did? I said we could do it. And we did it. And it was very, so I have a lot of skepticism about the purported lack of coercion in that the majority found. So I do want to just say a word about the facts because that is part of what happened. There are two things that the court did the majority does in the Kennedy, the praying football coach case, that are really extremely troubling just as a matter of lawyerly craft and how we're supposed to do our jobs. And one Colleen has already talked about, which is the way the court addressed the facts. The court zeroed in on 3 very specific events 3 games, took them completely out of context of the whole course of conduct, and over and over and over again described what the coach wanted to do as a moment of a quiet moment of private prayer. Over and over again, that's how the court characterized what he wanted to do, and therefore said that being restricted from doing that violated both his free exercise rights and his free speech rights. It wasn't part of his official duties. And he was doing this prayer during the moment when he otherwise could have been doing something else private, like checking restaurant reservations or checking his text messages. Those are the analogies the court drew. So if I can share my screen, Justice Sotomayor did something unusual, which was that she put some photographs in her dissent. These are photographs from the record. I'm just going to show you one. There were 2 in the opinion. So this is it. I should blow it up a little bit if I can. This is a picture of one of his private moments. This is him here in the middle holding up the football helmet. And these are players from both his team and the opposing team surrounding him for this quiet moment of private prayer. So just as a matter of lawyerly craft and what the court is supposed to do, it really, I think it's fair to say, misrepresented the facts of what was at issue in this case. The other thing the court did is to essentially announce that a very long-standing precedent that has long been in the sights of religious conservatives is no longer good law. But it did that without actually saying it was overruling it. The particular case is called Lemon and involves something called the Lemon test, which evolved into, there's some evolution here, but basically the question is there the question that the test asked was a version of, would a reasonable observer see that the government was endorsing religion? So you just saw that picture, right? This is happening at the 50-yard line and they're like this big, huge game. Would a reasonable observer consider that government endorsement of religion? And the court said, well, we don't really think that test applies anymore. There've been all these people have been questioning that test for years, and then cites a bunch of concurrences and dissents and lower courts complaining about the Lemon test, but doesn't actually come out and do the analysis that the court is supposed to do, and at least nominally did in Dobbs when it's going to overrule a precedent, to consider the various factors of stare decisis. Just didn't do that. The majority just kind of said, well, it's not really, nobody likes that, so it's not really good law anymore. Those are really, really problematic things for the court to do. The only good news about the fact piece of it is that maybe ultimately if you actually have a case involving that where the record can't be denied that the coach is doing what that picture showed you, that still would be unconstitutional, but I'm not sure. The bigger challenge, I just want to emphasize what Colleen said about sort of the separation of quoting Justice Sotomayor, that the separation of church and state itself is a constitutional violation. Historically, the court has allowed government entities to have a little what it calls play in the joints. So if it's trying to avoid an establishment clause violation, it can do things, right? It has a little bit of room that the establishment clause and the first free exercise clause aren't rubbing up against each other all the time. So if the state of Maine thinks, well, we don't want to run into an establishment clause violation, so we don't want to give money to these schools to provide religious education, which is what they are doing, the court says that no longer, they can't say we're trying to avoid an establishment clause violation to justify what the plaintiff and what the court sees as a free exercise violation or some kind of discrimination against religion. That has some pretty, going forward, will undoubtedly have some pretty significant effects. There's a piece of good news though here, which is that the state of Maine has already passed a law to address this. And the law they passed is that no school can receive this public money if the school discriminates against LGBT students, and I think also staff and faculty. So that is anti-discrimination. And this court even suggested that that might be something that the state could do, and it did it immediately. It's kind of amazing, right? It passed a piece of legislation immediately. We don't see that happening at the federal level, unfortunately. So they're troubling cases, and I think they will continue to have significant consequences going forward.
Yeah, that was the good news about the fact that it was the state of Maine that would pass that kind of legislation.
Yeah.
Other states would not.
Correct.
Can I just expand just a little bit on my answer and Carolyn's answer? I think that Justice Breyer's dissent was really profound in his appropriate and accurate treatment of history with respect to why the framers included both an establishment and a free exercise clause in the First Amendment. And it goes to the play in the joints point that Carolyn laid out. And it's, distilled to its essence. Justice Breyer says the First Amendment was intended to avoid or minimize the risk of religious strife. And that in a country as diverse as ours, with as many different religions and increasingly non-believers, or at least non-affiliated believers, that kind of avoidance of religious strife is so very, very, very important. And I flag that because of one of the more disturbing trends outside the court, which has been the ascension again of white Christian nationalism. And I think that many of the groups that were involved in the January 6th insurrection, many of the groups that got a lot of amplification during the Trump years, are allied with the white Christian nationalism move. And it really is a view of the country that basically perverts the history and says that, the United States was founded as a Christian nation. Not so. And then to just sort of presage, again, the court's bad jurisprudence in the abortion area. The white nationalism is also closely allied with opposition to reproductive rights. And you go back to the events in Charlottesville in 2017, and one of the chants was, "Jews, you will not replace us." And the notion that underlies all of this is that white Christian women do not have high enough birth rates, and that one of the problems with the advance of women's civil rights and civil liberties, but particularly the rights that are protected in the '64 Civil Rights Act, and particularly the reproductive rights that have been protected really since Griswold, going back to contraception, are contributing to these low birth rates. And it's, to state the obvious, a very, very toxic set of ideologies that, quite frankly, again, would eviscerate any real notion of the Bill of Rights and the Constitution being a protector of individual rights, and particularly minority individual rights, against majoritarian excess. And so I do want to flag that connection. I think it's a very disturbing trend. And I think that the jurisprudence of the court, but particularly in these two cases that we've just discussed, is going to add fuel to that fire and increase religious strife.
Thank you. I would not disagree. So let's talk a little bit about guns.
You have to.
now that another happy, unhappy topic. As we were waiting, and this was certainly before last week's, shooting in Highland Park and shooting on the south side of Chicago and all of that. We were waiting for the case that I think was argued in November, Bruin versus New York State Rifle and Pistol Association, the first gun case to be argued in many, many, many years. And we knew that it was probably going to come down that day. And I followed these cases on SCOTUS blog, which there's a constant people blogging all the time. And at one point, you know, somebody posted, no, we don't talk about Bruin, to the tune of the cartoon that we don't talk about Bruno. and you know, it just was this one case about concealed carry in New York, and really in New York City. So and I think everybody knew in advance how it would be decided by this court. But I'd like to hear your sense, both of you, about what the ramifications now, and now with this passing of this, in my mind, this incredibly weak, sort of almost nonsensical gun law that everybody is jumping up and down and applauding, that followed this. What does all this mean?
Well, I guess I can go first. I don't know that I have a sense of what it means for the particular provisions of the law that Biden just signed today. To be honest, I haven't followed the specifics closely enough to really be able to comment on them. But I can say a few things about the aspects of the opinion that I found that I think will have significant ramifications for meaningful gun regulation going forward. And that has to do with the method such as it is in this opinion. So this is another situation where I think, you know, when I was talking about the lawyerly craft and what was happening in Kennedy, another way of thinking about that is the rule of law, right? Judges aren't supposed to just misrepresent the fact. Judges aren't supposed to pretend that precedents have already been overruled when they haven't been. That's part of the rule of law. What happened in the Bruin case, I think also is a different kind of threat to the rule of law. And I will be, you know, I actually think it's one of the most intellectually dishonest opinions I've ever read. And I'll say more about why that is. Justice Thomas writes the majority opinion. We've known for many years that Justice Thomas has a very, very extreme position on the Second Amendment. He's been writing about it for a long time. He's been inviting litigants to bring these cases to the Supreme Court. And he said, well, I'm going to take this originalist view, which is also what the court said it was doing in Heller, the opinion from 2008, where it recognized a personal right to have our guns in the home for self-defense for the first time. He said, well, we're going to follow the same originalist methodology to consider whether people have a right to carry weapons outside the home for the purpose of self-defense. And there were ways, I think, to fairly criticize the New York law that would have been, you know, disruptive, problematic, but that would have been very different from what we saw. And I'll just say the New York law gave a lot of discretion to individual law enforcement officials to decide the scope of what kind of gun license and permission for carrying a gun that individuals would have. And I think, although I personally wasn't concerned about the decisions that were being made, I think there were reasonable arguments that could be made about the level of discretion that they had when it came to allowing people to exercise some version of a protected right. But that's not what happened. Instead we got a lengthy opinion about the nature of gun regulation or regulation of arms, not limited to guns, starting, in the 13th century and well, up to into the Reconstruction era. And the funny part about this is that every time there was a gun regulation that looked like it might be analogous to something like what New York was doing, the Justice Thomas said, well, that was too early, right? We can't, that's not really relevant because that happened too early, or alternatively, it happened too late. It was sort of like somebody said the Goldilocks approach to doing originalism, right? It's a way of, you claim to be looking at history, but there was a lot of history that was not favorable to the position that the conclusion he was reaching, and he found ways to wave it away. That is, what originalists claim is that originalism constrains them. It keeps them from just reaching their own, their preferred policy outcomes. And this opinion, I think, is exhibit A for why that is just often not true at all. This opinion manipulates the historical record in some pretty dramatic ways. And at one point, Justice Thomas says, sometimes originalists, I think this is a footnote, but I think he says it more than once. I find this kind of shocking, actually. He says, we get criticized because that our history, we're not doing good history, but we're not historians. We're lawyers, we're judges, and our job is just to resolve the case based on the record that's presented to us by the parties. And that I haven't actually completely formulated all the ways in which I find that deeply troubling. But if you're going to be an originalist, it seems to me that your first job is to be committed to getting the history right. And of course, historians will say there is no such thing as getting the history right, because there are lots of different strands of history. But to disavow that as what you're even attempting to do seems to me to kind of undermine the whole justification for originalism, which is this constraining this constraining effect that it at least presumptively has. So we don't know exactly what this means for future gun regulation, but we have it will not make it easy to have gun regulation of a certainly as comprehensive as many of us would like to see.
I agree wholeheartedly, and I would add that in addition to flunking history, the majority also flunks linguistics as in its application of quote unquote originalism, because it continues to disregard the terms well-regulated militia. And in addition, it disregards decades of jurisprudence, including in First Amendment speech area of time, place, and manner restrictions. And, I can basically go through every other amendment in the Bill of Rights, except for the Second Amendment. And there's a plethora of authority in which the court recognizes the right of government to impose certain regulations on the exercise of that right, so long as that regulation is justified by a compelling governmental interest, because after all, these are supposed to be fundamental rights, and the regulation is narrowly tailored so as to achieve that governmental purpose, that compelling governmental purpose, without riding roughshod over the rest of the right in its entirety. And increasingly, it seems to me that the only parts of the Bill of Rights that the court is applying anything close to the strict scrutiny that I think it should be required to support governmental regulation of a fundamental right is Fifth Amendment property rights, particularly of large corporations, and Second Amendment rights, and increasingly the free exercise rights of of Christians, because the court's other jurisprudence in terms of recognizing minority religions, whether it's the yarmulke of a Jewish member of the armed forces, or the religious liberty interests of people who are incarcerated, the court just is, riding roughshod over those rights. So I completely share Carolyn's view that this decision in and of itself, but the court's Second Amendment jurisprudence is dishonest, disingenuous, and not a good reading of either the Constitution or the history, and dangerous to boot.
Okay, well,
It's not getting more cheerful, Carol.
no, it isn't. And the last case that we're going to specifically discuss now.
Or did you want to talk about West Virginia versus EPA?
What?
Did you want to talk about West Virginia versus EPA before we talk about?
That's right, I did. We do. And I skipped that, and I apologize.
It's okay.
Yes, let's talk for a few minutes, because that is really important. The environmental case, West Virginia versus EPA, has all kinds of ramifications beyond the EPA. So let me let you take a few minutes to talk about that, because we do also want to talk about Dobbs. So let's talk about West Virginia versus EPA, and then we will talk about Dobbs. We may go past 7 o'clock. I hope people are willing to stay a little bit, and then put questions in the chat. And if we don't get to all of them, perhaps Carolyn and Colleen would be willing to, if we save the chat, just do some quick responses, and I'll get them to people, if that's okay. Or we can try and get to as many as we can. Okay, so I apologize. West Virginia versus EPA. Go for it.
I'll talk about it quickly. This is a case, it's a little bit technical sounding, but so I'm going to give a pretty high level description of what's going on. This is a case in which the EPA issued a rule under the Obama administration that essentially created a cap and trade system for carbon emissions. The plan was stayed by the Supreme Court. It was called the Clean Power Plan. And the Supreme Court stayed its implementation. The Trump administration came in and withdrew it, said we don't actually think we have the statutory authority to do this. We don't want to do it, which the second part certainly is within the power of a new administration. And the Biden administration has said it doesn't have any plans to implement it because it's going to create a different regulatory regime, going through a different process. So there are big questions about whether or not this case should even have been decided. That's also true in the Kennedy, the football coach case. There are big questions about whether or not that case was moot, but the court wanted to reach the merits, and it reached the merits. The issue in West Virginia is whether or not the EPA actually had the authority to impose this cap and trade system under the key statute at issue. And what's important here is not so much the ins and outs of the specific statute, which are technical and complicated, but the method that the court chose to use, which is something new and made up, that it is calling the major questions doctrine. And under this major questions doctrine, the court says, well, we think this particular decision is just so big and important. We don't believe that Congress actually delegated this authority to this agency. And unless since it didn't say so expressly, many of these cases involve rather general language that that the agency uses to implement certain rules. We saw another version of that earlier this term involving the vaccine mandate, that it was actually a vaccine or masking and testing mandate that OSHA put into place for workplaces of 100 employees or more. The court said that even though the OSHA Act, the Occupational Safety and Health Act, says in it that that OSHA has this authority to issue regulations to make workplaces safe. I'm not quoting the precise language, but it's basically a catch-all. That couldn't possibly extend to vaccination requirements because that's such a big deal. It's so controversial. And of course, OSHA had never before issued a vaccination requirement. It hadn't issued a vaccination requirement because we hadn't had a pandemic. So you might think that this was exactly why Congress, this kind of thing is exactly why Congress put this catch-all language in, was because they couldn't imagine or anticipate every conceivable workplace danger and wanted OSHA to be able to respond quickly. But the court said, no, that's too big a thing. That's too controversial. We just don't think that that's what Congress intended, or that's what Congress did. And that's essentially what they said in the West Virginia versus EPA case. It could have been worse, I should say, again. They could have decided on something called non-delegation grounds, which is a constitutional ground that would prevent Congress from giving agencies that kind of decision-making authority. They didn't go there, but they may yet. And it is one of a number of different moves the court has made to really restrict the scope and ability of the federal administrative state to operate.
Colleen, do you want to add to that?
No, nothing to add. So
Okay, the thing with this for me is that it affects more than just the EPA.
Yeah,
it affects other agencies, and that's the scary part for me. So let's look at Dobbs and you know the impact that we've all been just so upset and angry about and marching in the streets. Well, some of us have. I had a broken leg. I couldn't do the march, but where are we? And I know, Colleen, you want to jump right in.
We're screwed. You know, it's a really bad decision. Another example of the court's deliberate misreading of history. It's cherry picking of you know, one of the more misogynist of English English common law jurisprudentialists. And it's going to get worse, both in the Supreme Court and in the state legislatures around the country. I'm sure everybody on the call has read, you know, Justice Thomas's concurring opinion where he says the court should, you know, not stop with overruling Roe and eliminating federal constitutional protection for the right of abortion, but it should go on and overrule Griswold, stripping away constitutional protection from contraception, and it should also go on and overrule Obergefell, which established the right of same-sex couples to marry. And oh, by the way, while we're at it, let's just go on and overrule Lawrence versus Texas and eviscerate constitutional protection for same-sex intimacy or intimacy between consenting adults that doesn't fall into the standard missionary procreative view of Justice Thomas and you know, 5 other members of the court. And if I sound irritated, bitter, angry, it's because I am. I think that Justice Alito's misogyny, which was presaged in his decision several years ago, in the Hobby Lobby case, where he dismissed contraception as not real health care and so not problematic under, you know, it's not problematic under the Affordable Care Act. We see the same open disregard for women's health and dismissal about the real factual threats that pregnancy and childbearing pose to every woman, but particularly in the United States, which has the worst rates of maternal mortality and morbidity in the developed world. In fact, as somebody pointed out, also on SCOTUS blog, so I'm sure Carol has seen it, you have to go to the country of Moldavia in Europe to find another, industrialized nation that has comparably bad maternal mortality and morbidity rates as the United States. And if you are a Black woman in this country, your maternal morbidity and mortality rates are even higher. And we can at another session, and I did note that you have a health committee, talk about the many failings of our healthcare system and the systemic racism that is entrenched in it to this day. But for today, it will suffice to just comment on the majority's complete disregard for women as human beings, as citizens deserving the equal protection of the law, and having a fundamental right to make and effectuate decisions that are necessary to protect our own lives and health. I just want to briefly comment on again, the court's history, the fact that they say, well, abortion has always, by and large, been outlawed. It was outlawed at the time of in some states at the time of the Constitution, and it was outlawed, by the time of the Civil War. That is not universally true. Many states did not regulate abortion because they didn't regulate medical care, and they didn't regulate maternity and pregnancy and delivery in the early days. And there's a trove of historical support for the fact that abortion began to be outlawed after the Civil War, when there was a move to professionalize the medical profession and to take the delivery of medical care, particularly in the area of maternal health care, out of the hands of mothers, sisters, grandmothers, midwives, and put it in the hands of the increasingly professionalizing medical profession. And I think where I'm gonna leave people and turn it over to Carolyn, is one of the issues that one of the amicus raised, that I think is one of the more profound arguments in this area, and that again underscores how the Dobbs decision really does not, at the end of the day, recognize women as people with equal rights under the law. And it's other areas of healthcare, including other areas of healthcare that involve individuals and competition between individuals. There are a host of lower court decisions in both state and federal courts, in which courts have declined requests to force someone to donate a lobe of
liver, donate blood, donate bone marrow, even to a family member who needs that transmission of a bodily, of an organ or blood or bone marrow to save their own life. And the reason for that, the courts say universally, is that there is no compelling governmental justification for physically invading one person's life or posing an additional risk of injury or pain or suffering to that person in order to help another person. One court in Pennsylvania said, were we to do that, we would basically strip away one of the big distinctions of our respect for the rule of law and the system that
arose in Nazi Germany that, allowed the medical experimentation on some people for the purported benefit of others. So what that boils down to at its essence is that however strongly any of us, myself included, would feel a moral obligation to give a donation of blood or bone marrow or kidney or liver to our own live-born child, and I would, and I suspect almost everybody on this call would. If I can't be compelled to do that for my live-born child, why the heck can I be compelled to be forced to carry a pregnancy to term for a nascent human being that could not survive outside of my body? And for me, again, it distills down to the hijacking of our Constitution by a theology that at the end of the day really sees, women's eternal vocation, to quote the former pontiff, um, as motherhood, and that is really our role. And these abortion bans, which devalue women and force pregnancy upon us, are really, quite frankly, I think, a validation of that religiously dictated view of the role of women. And just to bring this around to the religious clauses, I'm going to shout out my friend and at times colleague, Sylvia Neal. Sylvia has always pointed out that in the Jewish faith, a woman whose life is threatened by continuing a pregnancy has a religious imperative to terminate that pregnancy. And so yet again, we see a situation in which the court is placing its thumb on behalf of one religious view of women, and quite frankly, the status of the fetus, as opposed to all others. And unfortunately, that argument has been made and lost in the Supreme Court, even in the days when Justice Blackmun was on the court. But I think it is a really important dimension of this issue.
So I'm not going to cheer you up after that. I'll just add a few things. One is just to add to the sort of dismissal of women as real, full human beings. To me, one of the more just offensive parts of the opinion was the discussion of reliance. Reliance is one of the things that the court is supposed to take into account when it decides to overturn a pre-existing decision. And it's a huge part of the analysis in Casey had to do with reliance. Casey was the case right in 1992 that everybody thought might overrule Roe and then didn't. Changed the test, but kept the core of the right intact. Casey spent a lot of time thinking about, those justices spent a lot of time thinking about reliance. And Justice Alito said, there's no reliance that we need to be worried about, because when we think about reliance in the context of stare decisis, what we really think about are things like property and contract rights. And that's just not an issue here. So there's nothing to worry about. Now, I mean, I'm sure, I don't even know where to start, but a number of really people, given this a lot more thought than I have pointed out all the ways in which contract and property rights are completely implicated by this, right? People who make decisions about where to go to school, people who make what state to live in, where to take a job, people who've made contractual agreements with the apps that they use to track their periods. There are all kinds of contract and property, I think more contract and property as well, rights or decisions that have been made in reliance, people's reliance on being able to have access to this kind of healthcare wherever they live in the United States. The other thing I'll say is that the consequences of this decision are much more, frankly, extreme than I had anticipated. And that's probably my own failure of imagination. But for example, I knew that there would be questions about whether or not people could travel from one state to another. And we're going to be seeing laws that are going to attempt to restrict that. We're going to be seeing laws that are going to attempt to criminalize or otherwise create liability for somebody helping somebody leave the state to get an abortion. And when you couple the likely existence of those laws with what the court did with respect to SB 8, it's really quite scary, because what the court did with respect to SB 8 was to say, yeah, there's nobody who can be sued to stop this law from going into effect. I would oppose a law like that. I think it's a completely insane system. And I actually think that some blue states should be passing laws that do the equivalent with respect to gun ownership and gun sales, not because I think that's a good way to run a country, I don't, but because I think then the court will have to reverse itself on this particular point. Maybe I have too much faith, but that's what I think would happen. So we're going to have all kinds of different enforcement mechanisms that are going to be experimented with to try to keep people from obtaining legal health care in other states. But the thing that I've been reading about that really has come as something of a surprise to me is things related to other aspects of healthcare. Lots of women who take drugs that might lead to abortions or that could cause a miscarriage are being denied these drugs, sometimes by their own doctors, sometimes by pharmacists who are refusing to fill prescriptions in situations where the women themselves either aren't being consulted about whether or not they are pregnant, want to be pregnant, right? They need these medicines for things like rheumatoid arthritis. They need the medicine for things, some of the, I'm not going to get the names of the medications correct because I can't ever keep them in my head, but one of the forms of medication abortion can be used to soften the cervix to make the implantation or the insertion of an IUD much less painful. That women have been denied prescriptions by pharmacists for that medication for that reason. We also have been seeing, yes, questions about chemotherapy, women who have ectopic pregnancies, and I honestly think this has a lot to do with the way some of the laws are written. It also has a lot to do with the way lawyers, like hospital lawyers are undoubtedly extremely risk averse and are giving the most risk averse advice possible. But a woman shows up with an ectopic pregnancy, there's no question about what's going to happen, right? This is not fixable in any way other than to remove the pregnancy from her body. Otherwise, both the embryo and the woman are going to die. And if the embryo is removed, only the embryo dies and the woman gets to live. Doctors in some states are finding that they are being told they have to wait literally until the woman is in sepsis or at death's door. So, because even if there's an exception for the life of the mother, it has to be at that moment of emergency. So those are things those are two consequences I frankly hadn't anticipated. Again, probably my own failure of imagination, but there will be more. I think there's all kinds of stuff we don't know yet about how this is going to play out in practice. Women who have miscarriages being prosecuted, or certain forms of birth control being criminalized. It's not going to be good.
And this is where I want to jump into one of the questions in the chat about the importance of the Illinois Supreme Court races. There is Illinois Supreme Court jurisprudence, but it's a little iffy that says that the state constitution protects the right to abortion. By and large, it uses the lockstep doctrine to say that our right of privacy, which is explicit in the Illinois Constitution, will be interpreted the way the U.S. Supreme Court interprets the right of privacy, which at the time of that Illinois Supreme Court ruling, the U.S. Supreme Court was interpreting the right of privacy in a way that protected individual rights. Obviously, that's no longer the case. And so it is extremely important. Not that I think anybody on this call needs to hear that validated, but I did want to respond to the question that people vote in the Supreme Court elections. And I have way too many friends who have had to listen to me say, you have to vote in elections. I don't care that the judicial ballot is long. Here is my cheat sheet. You have to vote. People have to vote on this. And you know, if people have concerns about voting for judges because they're not lawyers or because they don't know the judge's history, please refer them to you know, not only the bar referral services, but I would refer them to personal PACs, ratings of judicial nominees, because personal PAC does evaluate judges on the basis of whether they are supportive of a jurisprudence that protects the right of privacy. So please, 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 you know, please talk to everybody you know about the importance of voting, including in voting in the judicial elections.
I'll say one other thing about, I completely agree with that, all of it. I was reading today an article that talked about the Biden administration's reluctance to do as much as perhaps they could do. And one of the things that apparently some people in the Biden administration have been saying, and I'm sure not everybody has been saying, is, well, if we do X, the Supreme Court will strike it down. If we do Y, the Supreme Court will strike it down. And then other people are responding to the relatively tepid Biden administration response to Dobbs to say, well, we voted, now what? You know, you're not doing it. Why should I vote in the future? So, I mean, I don't think that this particular audience really needs to be, I suspect everybody in this audience already knows this, but I feel the need to say, right, it's not, no, it's vote, you have to vote, but it's not enough, right? You have to then go after your elected officials and tell them over and over again what you want. That's what the religious conservatives did for 40 plus years to get to Dobbs. It's not like it happened overnight. And so it's not, voting is essential, but it's not enough. And the other thing I would say on this question of, you know, what if the Supreme Court strikes this down? I think that is not a reasonable concern. I really don't. Not that one should be completely, you know, reckless, but the Supreme Court's going to strike down a lot of stuff related to abortion, related to other things. They're going to strike down a lot of stuff. But they're not going to strike down, A, they're not going to strike down everything. And B, if they do strike things down that are popular, right, that's an important moment for organizing. Whereas if our side, just doesn't do anything, that's just surrender, right? And there's no way to organize around surrender. So, you know, I just, I read that today. I don't remember where I read it. And, you know, my head kind of exploded a little bit.
And I totally agree with Carolyn. And Illinois is a perfect case example in that, in part because of all of the activism of many of the people on this call. And I know who you are. When I started at the ACLU in 1984, the Illinois General Assembly was enacting a toxic abortion ban that also went after contraception, that went after prenatal testing, that went after assisted reproduction, which was in its nascent stages, every year. And the ACLU would go to court every year, sometimes a couple times a year, in federal court, and get those laws struck down and ban the state from enforcing those laws on the basis of all the doctrines that Carolyn and I have been weeping over and tonight, and their demise. And the handwriting has been on the wall for, unfortunately, a number of years, at least since Casey, when you know, that case initially was framed as overruling Roe. And activists here in Illinois went to work to change the composition of the Illinois General Assembly. And it took a long time. But over the last 8 years, the Illinois General Assembly has passed a number of hugely protective bills in the area of abortion, the Reproductive Health Care Act, the repeal of the Parental Notice Act, the expansion of Medicaid funding, the repeal of an Illinois trigger law that would have banned abortion had Roe gone into effect, a scaling back of the Healthcare Right of Conscience Act. And before Obergefell, we enacted a change to the Illinois Marriage Act and Dissolution of Marriage Act that legalized same-sex marriage. And a few years before that, we added provisions to the Illinois Human Rights Act that provided state-level protections against discrimination on the basis of sexual orientation and gender identity. And so it's important to remember that the federal Constitution is a floor, by and large, below which protections for individual rights cannot fall. Unfortunately, this Supreme Court is pushing that federal floor into the sub-basement, but states can provide more protection if they so choose. I think that the court's decision a couple terms ago in the Montana religion case that preceded the main case that we talked about tonight gives me the creeps in terms of how much authority we are going to provide or recognize for state constitutional conventions to provide more robust, more modern protections for individual rights. But it is possible to do this. And I just am going to say, I couldn't agree more with Carolyn that surrender is not an option. We cannot organize around surrender. We just have to continue to push forward. And we know it works here in Illinois. And so, I think that it's on, as always, it's on us.
So let me, because we're really running out of time. There's a couple things in the chat. One is asked about impeachment. That is the only way you get rid of a Supreme Court justice. It is rare. I think it's happened once, maybe twice in the whole history of this country. It would take a lot for it to happen. Although, yes, they did lie. They said they'd uphold Roe v. Wade. They're not doing it. So, and we probably knew that. I would be remiss if I didn't say, when I was discussing this with my husband, he said, you have to say that these were well-purchased decisions. A lot of money went into making sure that these justices were appointed to this Supreme Court. This is dark money. This is money from all kinds of places. And don't think that the money, when we want justices, doesn't come in as well. So just know these things happen. So we have a lot of work to do, and this is the right group to do it. You are right. We have to organize, and we have to make sure things that we want to see happen. This is the right group to do it. So on behalf of Chicago Women Take Action, I want to say a huge thank you to Carolyn and Colleen. You didn't make us happy, but you made us smarter. So we really appreciate that. We could go on and talk forever about this. This is why I'm a court junkie. And we've learned some things, and we will move on and do more. For those of you that are on this call and not members, join us and keep coming, and we will make change together. Jackie, you want to close us out?
Thank you, Carol, Carolyn, and Colleen. Hey, it's triumph of seeds tonight. So thank you very much. You know, as Carol said, you have definitely made us smarter, if not happier tonight. And I wish we had another couple hours, because I was just sitting here intrigued, enthralled, and I bet a lot of questions here. If you care to answer them, I'm sure the folks who are attending would love to hear your answers. We are recording this, so those folks who are on our mailing list, I don't want to say when it's going to be up, because Sherry's in charge of that, and I don't speak for other folks. But you know, we will have a recording that's available at some point or another, because you know there was so much richness here. I love to hear it again myself, you know, just having sat here and my mind getting blown every 2 seconds by what you're saying. But yeah, if we could teach these guys, or as I prefer to say, if I could fire these guys, you know, that's the way I'd like to do it. You're fired, you know, kind of thing. But thank you. It's been wonderful. And we meet every first Monday usually, but the 4th of July pushes to the second Monday. And Colleen, I think Mary has an open invitation for you to join the health committee to help us with reproductive health care and so forth. And Carol, you want to add one more thing before I
Yeah, just if any of you are associated with organizations, Courts Matter Illinois is sending an organizational letter to Senator Durbin to speed up the appointment of federal judges, get them all filled by the end of this session before the midterms. Organizational sign-on letter. We need organizations to sign on by Thursday morning of this week. So if you want to contact Courts Matter Illinois or me at Carol with an E, Carol Levine at Comcast.net. If you think your organization would like to sign on to the letter, send me an email. I will send you the letter and instructions on signing on. But we've got to get it to him quickly.
Yeah, we got to block the Federal Society from putting any more people on the bench as much as possible. So yes, if you can do what Carol asked, I think is important, because every little thing we can do is one more step in fighting back, you know, that we can't surrender. So thank you both, Carolyn and Colleen. I cannot express my gratitude any more than I'm stumbling over my tongue, because I am so, you know, upset, but, you know, educated for what you've done tonight. So thank you all. I hope to see all of you next month. Sherry, do you want to say something about when the recording might be available before we hang up? Unmute yourself though.
Yep.
There you go.
Yeah, I will probably have it available even in just a couple days, 2 days or so.
All right, so be back in touch and you can hear the recording. I know I'm going to listen again. So thank you all. Have a wonderful evening, and I hope the rains don't come and get us like they were talking about. Bye-bye.
Bye, everyone.
Sherry, you got this?
I do.
Okay. All right. Good night. You have a great evening.
You too.
Thank you. Good night, everybody. It was wonderful.
Very good meeting.